In the High Court of South Africa, Limpopo Division, Polokwane, case number 2963 of 2024, in the matter between Benja Enterprise as the plaintiff and Minister of Public Works and Infrastructure as the defendant. Notice in terms of Rule 42(1)(b) is the heading. May it please the court to take notice that the plaintiff applies in terms of Rule 42(1)(b) for the court to, in addition to any other power it may have, meromotu, rescind or vary an order or judgment in which there is an ambiguity or patent error or omission, and make the draft order an order of court and pronounce it virtually or by circulation on or before Friday, the 20th day of September 2024 at 1200 under the following circumstances. The relief sought. The matter is unopposed and in sort of relief. The plaintiff performs diligently and without delay a constitutional obligation at Section 1951G of the Constitution, obligating that public administration must be governed by the democratic values and principles enshrined in the Constitution, including the principle that transparency must be fostered by providing the public with timely, accessible, and accurate information. And the relief sought is the matter being enrolled as an urgent action. Payment of the sum of 4,949,582 rands and 99 cents, inclusive of all of value-added tax. The interest on the sum of 4,949,582 rands and 99 cents, inclusive of value-added tax at the rate of 24% per annum, calculated from 26 March 2024 to date of payment and cost of suit. The background of this matter is such that the Honourable Court issued the summons on Tuesday, the 26th day of March 2024, informing the defendant of an action instituted by the plaintiff wherein he claims payment of the amount of 4,949,582 rands and 99 cents, and interest at the rate of 24% per annum, calculated from 26 March. The defendant was informed further that he or she must file his or her notice of intention to oppose on Thursday, the 11th day of April 2024, or within 10 days, and to file a plea, if any, on Thursday, the 9th day of May 2024, or within 20 days. No notice of intention to oppose was filed and no pleadings were made, and subsequently, the plaintiff enrolled the matter for a default judgment on Tuesday, the 23rd day of July 2024, under the circumstances explicitly set out on page 22 to 23 of the record of court. As a result of executing and operating on 13 June 2024, a decision whose operation and execution is suspended pending the conclusion of Constitutional Court Case number CCT 141/24. The state unlawfully detained the plaintiff's representative without trial, and the state failed to comply with the order of this court for the plaintiff's representative to appear before court on 23 July 2024, and the matter was removed from the roll. On Wednesday, the 28th day of August 2024, the Honourable Court re-enrolled the matter for hearing on Thursday, the 7th day of November 2024 at 1000 or as soon thereafter as the parties may be heard under the circumstances explicitly set out on page 27 to 28 of the record of court. The plaintiff on page 33 to 35 of the record of court moved a notice of motion in terms of Rule 612, dispensing with the forms and services provided for an urgent action to be filed before noon on Thursday, the 5th day of September 2024, and disposed of such matter at such time and place and in such manner and in accordance with such procedure that is as far as practicable allowed the matter to be heard on Tuesday, the 10th day of September 2024 at 1000 or as soon thereafter as the parties be heard. In the affidavit or petition filed on page 36 to 39 of the record in support of the application, The plaintiff had on paragraph 4 therein explicitly set forth the circumstances which he avers renders the matter urgent and the reasons why he claims that he could not be afforded substantial redress at a hearing in due course or on 7 November 2024. No notice of intention to oppose was filed by the defendant, and when the trial was called, the plaintiff appeared and the defendant did not appear, and the plaintiff proved his claim insofar as the burden of proof lied upon him, and judgment was to be given accordingly, insofar as he has discharged such burden as obligated in terms of Rule 39(1). But the Honourable Court erred to comply with its rules or neglected the plaintiff's prima facie right to safety and security, or a right as the owner of a property, or a right arising out of a contract or agreement of sort that needs to be protected or enforced as advanced, and ordered the plaintiff to sought legal representation. The plaintiff re-enrolled the matter in terms of circumstances explicitly set forth on page 53 to 55 in the notice of set down head on Thursday, the 12th day of September, in which the Honourable Morgan A.J. issued an order or judgment that is unconstitutional, unlawful, or invalid, and must be set aside as a result of an ambiguity or a patent error or omission to promote the spirit, purport, and objects of the Bill of Rights enshrined at Section 38 of the Constitution and the law at Section 4 of the Consumer Protection Act. Regarding prejudice or irreparable harm, the plaintiff is prejudiced, and on a balance of probabilities, the plaintiff will suffer irreparable harm if the court does not make the draft order an innovative order that better advances, protects, promotes, and assures the realization by consumers of their rights, and the defendant will not suffer any harm if the court orders. Service and defense in accordance with the Constitution and the law. The plaintiff's representative, Sylvester Volane Mangolele, is national security, a peace officer, or a justice of peace with force number 99004046 MC, holding permanent commission to a rank of lieutenant commander, and has since 13 January 2003 to date pledged to serve and defend the country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. As Welch put it in his book titled Winning, at page 83, integrity is something of a fuzzy word, so let me tell you my definition. People with integrity tell the truth, and they keep their word. They take responsibility for past actions, admit mistakes, and fix them. They know the laws of their country, industry, and company, both in letter and in spirit, and abide by them. They play to win the right way by the rules. Rule 42(1)B is held by the Honourable AML Patudi J in the matter between Mpephu Ramabulana royal family and the Premier, Limpopo Province, and 4 others in the Limpopo Division Toyando case number 2016 of 2022 at paragraph 3, citing that the court may, in addition to any other power it may have, meromuto or upon the application of any party affected, rescind or vary an order or judgment in which there is an ambiguity or a patent error or omission, but only to the extent of such ambiguity, error, or omission. On Thursday, the 12th day of September 2024, the Honourable Morgan A.J. issued an order or judgment that is unconstitutional, unlawful, or invalid, and must be set aside in its entirety, rescinded or varied as a result of an ambiguity or a patent error or omission to promote the spirit, purport, and object of the Bill of Rights enshrined at Section 38 of the Constitution and the law at Section 4(1) of the Consumer Protection Act, respectfully obligating that anyone listed in the section has the right to approach a competent court alleging that the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. The persons who may approach court are anyone acting in their own interest, anyone acting on behalf of another person who cannot act in their own name, anyone acting as a member of or in the interest of a group of or class of persons, anyone acting in the public interest, and an association acting in the interest of its members. And realization of consumers' right in terms of Section 4.1 of the Consumer Protection Act is such that any of the following persons may, in the manner provided for in this Act, approach a court, the tribunal, or the commission alleging that a consumer's right in terms of this Act have been infringed, impaired, or threatened, or that prohibited conduct has occurred or is occurring. A person acting on his own interest or her own behalf. An authorized person acting on behalf of another person who cannot act on his or her own name. A person acting as a member of or in the interest of a group or class of affected persons. A person acting in the public interest with leave of the tribunal or court, as the case may be, and an association acting in the interest of its members. Fundamental founding values of our democracy are such that human dignity, the achievement of equality, and advancement of human rights and freedoms are the first founding values of the Republic of South Africa, which is one sovereign democratic state where there is a common South African citizenship in which all citizens are equally entitled to the rights, privileges, and benefits of citizenship and are equally subject to the duties and responsibilities of citizenship as obligated in terms of Section 3 of the Constitution. And the Honourable Court solemnly affirmed that it will be faithful to the Republic of South Africa, will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice in accordance with the Constitution and the law, and so help me God. A prayer to all judges. In State versus Mangale, in terms of case number 248 of 2022 in the Magistrate Court of Simonstown, the presiding magistrate, Mr. Vali, advanced on record of court on 5 July 2024 that he does not care about the Constitution and the law. He does not care about oath and God, causing the plaintiff's representative to appear before this court on 23 July 2024. And such incident shall be dealt with in terms of Constitutional Court case number CCT 141 of 2024. And the integrity of the Honourable Morgan AJ is called upon not to be part of the people who do not care about the Constitution and the law, and who do not care about oath and God, as such law or conduct is treason, criminal activity, corruption, or misconduct. God helped the plaintiff to appear before court, for the plaintiff is facing other court actions whose relief relies on the relief sought before this honourable court, my Lord. It costs money for the plaintiff to drive more than 2 hours to court and another 2 hours or more to drive back to his place of residence, whose trust is threatened by sequestration action, which also relies on the relief sought, and to make a court order compelling the plaintiff as the people of this country not to be served and defended in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity as currently done, and to seek legal representation that he must pay for to move his urgent action is not in the interest of justice. For the defense force is the last line of defense when organs of state fail. Pursuant to the directive given on Thursday, the 12th day of September 2024 by the Honourable Morgan AJ, for the plaintiff's representative to explicitly set forth in writing his motion in terms of Rule 49(1) of the Uniform Rules. The parties are before the court to resolve a dispute by the application of law decided in a fair public hearing as obligated in terms of Section 34 of the Constitution. And it is incumbent that organs of state through legislative and other measures, must assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness as obligated in terms of Section 1654 of the Constitution. An Act of Parliament in terms of Milestone 2 of the South African Defence Review 2015 seeks to rebalance and reorganize the Defence Force as a foundation for future growth. The extent of such ambiguity or error or omission threatens or infringes the plaintiff's prima facie right to freedom and security of the person, and freedom of trade, occupation, and profession guaranteed in the Bill of Rights, and that must be respected, protected, promoted, and fulfilled by the Honourable Court as obligated in terms of Section 12 and Section 22 of the Constitution. Security services promoting the values that underline an open democratic society based on human dignity, equality, and freedoms is in terms of Chapter 11 of the Constitution, mandating at Section 1995 that the security services must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. The primary object of the Defence Force is to defend and protect the Republic, its territorial integrity, and its people in accordance with the Constitution and the principles of international law regulating the use of force as obligated in terms of Section 202 of the Constitution and the law at Section 2B of the Defence Act. And it is incumbent for the plaintiff's representative as an individual to contribute to the best of his abilities at all times and at all levels to the promotion and achievement of African unity as obligated in terms of Article 29.8 of the African Charter on Human and People's Rights. Excuse me. The order or judgment erroneously granted on 12 September 2024 is in direct assault to the statutory framework at Section 3 of the Constitution and Section 200 of the Constitution by promoting law or conduct inconsistent with the obligations imposed in terms of Section 38 of the Constitution and the law at Section 1B, 41B of the Consumer Protection Act for only a person with LLB qualification to represent the plaintiff. LLB qualification is not the supreme law. The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. And all constitutional obligations must be performed diligently and without delay as obligated in terms of Section 2 and Section 237 of the Constitution. And this is the law of the land that a judge must comply with at all times, also in extrajudicial conduct as obligated in terms of Article 6 of the Code of Judicial Conduct. And in any event, the Bill of Rights applies to all law, including the LLB qualification, and binds the legislature, executive, the judiciary, and all organs of state as obligated in terms of Section 8.1 of the Constitution. Any willful or grossly negligent breach of the Code of Judicial Conduct, including any failure to comply with the obligations imposed in terms of Section 1652 of the Constitution for the courts to be independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice, shall be construed as incapacity giving rise to a judge's inability to perform the functions of judicial office in accordance with prevailing standards, or gross incompetence or gross misconduct as envisaged in Section 177(1)(a) of the Constitution. In this matter, the terms anyone or person is by ambiguity or a patent error or omission interpreted as only the person with LLB qualification has the right or locus standi to approach a competent court, alleging that a right in the Bill of Rights has been infringed or threatened, and that the persons who may approach the court are not anyone acting in their own interest, anyone acting on behalf of another person who can, and not on their own name, anyone acting as a member of or in the interest of a group of or class of persons, anyone acting in the public interest, and an association acting in the interest of its members. If not rescinded or varied, the order or judgment promulgates a reality in which the Bill of Rights does not apply to all law as obligated in terms of Section 8.1 of the Constitution. The true intention of the Honourable Court may be to secure and defend the Legal Practice Act established in terms of Section 22 of the Constitution. The Honourable Court is equally bound to do same with the plaintiff's rights enshrined in the same constitutional obligations whose security is represented by the defence force as defined at Section 200 of the Constitution, obligating that the defense force must be structured and managed as a disciplined military force. The primary object of the defense force is to defend and protect the Republic, its territorial integrity, and its people in accordance with the Constitution and the principles of international law regulating the use of force. To provide for the defense of the Republic and connected therewith. It is principle envisaged at Section 2 of the Defence Act obligating the Minister and any other organ of state defined in Section 239 of the Constitution, as well as all members of the Defence Force and any auxiliary service and employees must, in exercising any power or performing any duty in terms of the Defence Act, have regard to the following principles. The formulation and execution of defense policy is subject to the authority of Parliament and the National Executive. The primary object of the defense force is to defend and protect the Republic, its people, and its territorial integrity. The defense force must perform its functions in accordance with the Constitution and international law regulating the use of force. The defense force must have a primary defensive orientation and posture. No member of the defense force may obey a manifestly illegal order. Neither the defense force nor its members may, in the performance of their functions, prejudice a political party interest that is legitimate in terms of the Constitution or, in a partisan fashion, further any interest of a political party. The defense force must respect the fundamental rights and dignity of its members and of all persons. To manage and structure the defense force as a disciplined military force is obligated in terms of Section 201 of the Constitution. Section 9.2 in the Bill of Rights is a constitutional obligation that is performed diligently and without delay for equality to include the full and equal enjoyment of all rights and freedoms. And the Honourable Court is called to meromotu, rescind or vary the orders given, and comply with the supremacy of the Constitution and the rule of law, and promote the achievement of equality by taking legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination, as it is the case with the plaintiff. The prevailing standard for judicial conduct at Article 6 of the Code of Judicial Conduct obligates the judge to at all times, also in relation to extrajudicial conduct, comply with the law of the land, to respect, protect, promote, and fulfill the rights in the Bill of Rights for everyone to achieve their right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum as obligated in terms of Section 34 of the Constitution and the law at Section 9.1 of the Superior Courts Act, obligating the court to perform its duties, including on a Saturday, Sunday, or any public holiday. For God has indeed blessed Africa. Papa Uti.